Data used in the film was culled from an update on XRP's market capitalization. Verify the most recent dates thoroughly. The spat with the SEC has also contributed to Ripple's growth. The Securities and Exchange Commission and Ripple have been involved in a protracted litigation dispute. There will probably be a resurgence of activity in the lawsuit as key deadlines approach. Legal issues have been a major source of stress for the XRP environment, thus the XRP community is understandably going to be watching this case closely. It looks like Ripple and the SEC are heading for yet another legal battle. The former federal prosecutor James Fan announced the initial short restriction established by the Securities and Exchange Commission on March 22nd on X, the platform formerly known as Twitter. Yes, Ripple will have to wait until April 22nd to present its case. The Securities and Exchange Commission (CC) is required to submit its reply brief by May 6th, the deadline. After the assignment is completed, these schedules reflect the most current revisions to the remedial briefing plan. The original deadline for submitting the preliminary report to the SEC was March 13th. At that point, it was originally planned to take place. Nonetheless, the Commission had pleaded with Judge Analisa Torres for an extension, citing a valid reason. The scheme was approved by Judge Torres after much deliberation. The CC has also requested that Ripple be given until April 22nd instead of April 12th to submit its counterbrief. The purpose of this postponement is to provide the accused with an opportunity to respond in writing to the evidence brief submitted by the Commission. This phase follows the period of discovery. Here is where the authority in charge requests specific paperwork from Bitcoin Corporation. Initially, there is a distinct step known as the opening brief, which is also known as the remedial briefing stage. The SEC's opening brief, which includes contracts with institutional sales organizations, will be based on these facts due to a complaint. After what it claims is a breach of securities regulations by Ripple, the Commission is likely to demand several repairs. This is a very intriguing topic. Judge Torres, this line is incomplete on an earlier ruling. Give us more details so we can finish it. Some potential results of the remedial meeting are as follows. In order to prevent Ripple from engaging in institutional sales that violate securities regulations, the SEC is likely to seek an injunction. Ripple will probably be found as well. To what extent the Bitcoin company's sales to institutions constituted investment contracts was a matter for Torres to determine. Ripple may challenge the severity of the fine imposed by the Commission if things don't work out as planned. Ripple may further argue that its worldwide decentralized loan transactions do not qualify as securities. An earlier statement by attorney John Dion suggested that the parties may still be required to submit follow-up paperwork. Because of this, the remedy briefing would not proceed as easily as initially. According to Deaton, the decision won't be made until the summer comes to a close, regardless of how late it is. The Bitcoin community is currently holding their breath, hoping that the court will formally dismiss the lawsuit. Nonetheless, a post-decision appeal by one party is always a possibility. Represent the end of the protracted legal dispute that the U.S. Securities and Exchange Commission and the blockchain corporation Ripple have been in. The revised timeline calls for Section 2 to submit its opening brief no later than March 22nd. Defense counsel James K. most recently submitted a report about the Ripple CC case. The deadline for Ripple to submit an objection following Filan's March 14th is April 22nd. The deadline for the regulator to respond is May 6th. Selling XRP to institutional customers was deemed equivalent to purchasing securities in July 2023 by Judge Analisa Torres, in case you missed that. Transactions involving the purchase of XRP from ordinary individuals were not considered stock sales. Now that all parties are attempting to reach a consensus on the amount of damages that Ripple should pay, you can take a look at the stock that is outperforming the market and generating billions of dollars for investors. We are doing this so that you can give some thought to the stock. Pendle might be included after 13 minutes. The SEC's request was approved due to the information provided by Filan and the former federal counsel at the time. Supporting the proposal for an increase, this supplemental paper demonstrates specifically what the blockchain sector is worried about and how the SEC is responding. The legal team representing the regulatory watchdog emphasized during the briefing that this was the proper rationale in accordance with federal civil process legislation. Furthermore, they emphasized the significance of exercising caution while interacting with the SEC in selecting discovery tactics and a briefing. Additionally, the motion stated that Ripple had already granted the SEC's request and that Magistrate Judge Sarah Netburn had previously authorized the postponement of the initial discovery date. Ripple is given 9 additional days to submit its initial brief. according to the letter. Because of this, events transpired. On March 1st, the SEC expressed their want to alter the briefing strategy. Deedon quickly followed up by including a statement confirming the court's approval of the modification. Those following the cryptocurrency market are now paying great attention to any coverage of Ripple CC in the media, scanning the scene for any signs that would provide light on the outcome of the Ripple v. CC lawsuit. The issue is complex and may go to appeals, so a settlement before 2026 seems quite unlikely. A new research from the European Corporate Governance Institute details the reasoning behind the court's ruling that XRP constituted a security despite the fact that it was sold directly to institutional customers rather than publicized to the public on an exchange. The decision was taken early this year. Now that this lawyer has seen this, their perplexity has just increased. A prominent member of the XRP community named Bill Morgan responded to Ronan's statement by saying the following. The remark wasn't helpful, Morgan continued. Some people are still falling for it, even inside the XRP community. Due dates for rectification reports have been rescheduled on both the XRP and the SEC sides as a result of the ongoing court case. Many people in the cryptocurrency industry are quite curious about this situation. The new information has greatly increased the significance of this aspect of the continuing war. Considering Ripple's request for further time to pursue legal action against the SEC, the opening report is expected to be sent by the Securities and Exchange Commission no later than March 22nd. Ripple is expected to submit its counterbrief no later than April 22nd. Following that, the SEC will have until May 6th to submit the response brief. Notable attorney James K. Phelan, who has been closely monitoring the dispute between Ripple and CC, just announced the revised date for the remedy briefing. The most recent scheduling modifications caused the delay that was already knew about. The discovery occurred in February.